Okay, students, welcome back. Now, students, our next topic is the development of the notion of the war crimes. So, here is the list of topics. The developments of the notion of the war crimes. Students, as discussed earlier, a number of the rules have been developed in international humanitarian law, which concerning the appropriate behavior behavior and conduct during the armed conflicts. But however, this does not mean that every violation of the international humanitarian law will amount to a violation of the war crimes. That is, the war crimes only deal with the criminal responsibility for the serious violation of the international humanitarian law. In this in this connection, war crimes are secondary rules which criminalize a segment of the primary set of rules concerning behavior that is prohibited during the armed conflict. The question then is which violation amount to war crimes? How distinguish war crimes from the violation of the humanitarian law? An overview of the history of the notion of the war crimes served as the useful starting place for the understanding which violation amount to criminal misconduct. This section will therefore provide a review of the key developments relating to the notion of the war crimes. The First World War, students, the Treaty of Versailles. The early development of the concept of the war crimes to international law can be traced back to the First World War. Though the war witnessed countless atrocities by all sides of the conflicts, criminalization of the atrocities was under the Peace Treaty of Versailles limited to the actions of the German and Austro-Hungarian forces and their allies. According to Article 228 of the Treaty of Versailles, provided that the German government recognized the right of the Allied and associate powers to being before military tribunals persons accused of having committed acts in violation of the laws and custom of the war. The Allies urged the prosecution of the nearly 900 enemy military personnel for the violation of the laws and the custom of the war. However, in the end, only a small number of them were actually convicted. In the history and background of the international community, we have discussed these points at a length. So that was the basic treaty which actually regulates the conduct of the rules of the war and armed conflicts. The further when failure of these conventions, the Second World War, which occurred in the 1940, start from 1945. The Second World War, which resultantly the atrocities during the Second World War tried by the Nuremberg and Tokyo charters, the notion of the war crimes revised as a result of the events of the Second World War. The drafters of the Nuremberg Charter of the International Military Tribunal and the Tokyo Charter of International Military Tribunal, including war crimes within the jurisdiction of the crimes attracting individual responsibility. Article 6, Clause B of the Nuremberg Charter define the war crimes, which is I'm going to read out. The war crimes, namely violation of the laws or custom of war. Such violation shall include but not be limited to murder, ill treatment of deportation to slave labor, or for any other purpose of the civilian population of or in occupied territory, murder or ill treatment of the prisoners of war, or persons on the seas, killing of the hostages, plunder of public or private property, women destruction of the cities and towns or villages, or devastation not justified by the military necessities. In a Tokyo Charter, which include war crimes in Article 5, Clause B, conventional war crimes, namely violation of the laws or custom of the war. Uh, but but the two charters, like the Treaty of Versailles, refrained from the providing a precise definition of the violation that would constitute a breach of the laws of the war. They did provide examples of the prohibited acts. However, even with the example of impugned acts contained in the Article 6 of the Nuremberg Charter, it remained unclear as to what constitutes a war crime. For instance, although a murder was listed as an example of the prohibited act, it is unclear from the words of the Nuremberg Charter when a murder would be amount to a war crime. So therefore, there was the one of the main criticism arose on the Article 6 of the Nuremberg Charter and the Article 5 of the Tokyo Charter was that they did not reflect the international law. In particular, the main contention was that the Hague and Geneva Convention only governed the actions of the states and did not create individual criminal responsibility. So the next, after the failure of those, the next development is the Geneva Convention of the 1949 and the additional protocol. As earlier discussed, the atrocities committed during the Second World War inspired the development of the Geneva Convention of 1949, four further conventions for the protection of the victims of the armed conflicts. Each Geneva Convention sets out a definition of the protected persons, which are those individuals whom the provision of the particular convention seeks to protect. For example, Convention number 1, 2, and 3 define protected persons as members of the armed forces of a party to the international armed conflict who are no longer engaged in hostilities due to injury or capture. Whereas under Convention 4, protected persons are defined as the persons who are in the hands of the party to the conflict of which they are not nationals. The Geneva Convention 1949 represents a highly significant element in the attempts to codify the concept of the war crime. However, the Geneva Convention do not use the term war crimes, but instead refers to grave breaches. Only Article 85, Clause 5 of the Additional Protocol 1 of 1977 to the Geneva Convention states that grave breaches are to be regarded as the war crimes. So, war crimes are therefore only the most severe atrocities suffered by the civilians and non-combatants. Article 85 of 1977 Additional Protocol, which relates to the international armed conflicts, provides the greater precision to the concept of the war crimes by including an additional list of the acts that are deemed to be the grave breaches, which including making the civilian population or individual civilians the object of the attack, launching an indiscriminate attack affecting the civilian population or civilian objects in the knowledge that such attack will cause excessive loss of life, injury to the civilian, or damage to civilian objects, and launching an attack against the works and installation containing dangerous forces in the knowledge that such attack will cause excessive loss of life, injury to the civilian, and making non-defended localities and demilitarized zones the object of the attack, making a person the object of attack in the knowledge of that he is horse de combat, the perfidious use in violation of the Article 37 of the distinctive Red Cross, Red Crescent, and Red Lion, and son of the other protective signs recognized by the Convention of this protocol. So, if the states, the armies, forces will take on those signs, will be the violation of the Article number 37 of the Geneva Convention. The main international humanitarian laws treaty provision relating to the conflict of the non-international character is common Article 3 of the 4th Geneva Convention of the 1949, which provides basic norms recognized to apply even in non-international conflicts. Regulation of the internal armed conflict in common Article 3 was expanded by the additional Protocol 2 of the 1977. So here's the common Article 3, which provide that persons taking no active part in the hostilities, including members of the armed forces who have laid down their arms, and those place hostage combat by sickness, wounds, detention, or any other cause, shall in all circumstances be treated humanitarian under the humanitarian law without any adverse distinction founded on race, color, religion, or faith, sex, and birth or wealth, or any other similar criteria. So these were the ingredients of the Article 3 of the Geneva Convention. So thereafter, students, there are other ad hoc international criminal tribunals which we have already discussed. Likewise, two ad hoc tribunal: number one, ISTY, International Criminal Tribunal of Yugoslavia, and ISTR, International Criminal Tribunal for Rwanda. So, grave breaches of the Geneva Convention, and during the ISTY, the main feature of that tribunal, the international tribunal shall have the power to prosecute persons committing or ordering to be committed grave breaches of the Geneva Convention, 12 August 1949, namely the following act against the persons or property protected under the provision of the relevant Geneva Convention: willful killing, torture, or inhuman treatment, including biological experiments, willful causing great suffering or serious injury to the body or health, extensive destructions and appropriation of property non justified by the military necessity, and carried out the unlawfully those actually carried out unlawfully, and compelling prisoners of war or civilian to serve in the forces of the hostile power, willfully depriving a prisoner of war or a civilian of the rights of fair and regular trial, unlawful deportation or transfer, or unlawful confinement of the civilian, taking civilian as hostages. So these were the main feature of the that tribunal, that trial, which we have earlier discussed in first part of our this course, and during the jurisdiction of those tribunals, ad hoc tribunals, mixed hybrid tribunals. So in that tribunal, in a nutshell, the following four categories of war crimes appear to be fall within the ambit of the Article 3. The Article 3 of the Geneva Convention, the feature ingredients further interpreted during that tribunal, ISTY, uh, they categorize, there are four war crimes. Number one, violation of the Hague Law; non-grave breaches of the Geneva Conventions; violation of the common Article 3 of the Geneva Convention; and violation of the customary laws. So that the students, that is the main feature of the development during the trial of the ISTY. So next development, the main feature of the next tribunal, that is the international court of the International Criminal Tribunal of the Rwanda. Unlike the former Yugoslavia, the conflict in Rwanda was widely accepted to be a non-international armed conflict. The UN Security Council contributed to the development of the war crimes law in the internal conflicts by adopting a statute of ISTR in which the rules of international humanitarian law, which apply to the non-international conflicts, were set out. The Security Council concluded that the rules which apply to the non-international armed conflicts are common Article 3 and additional protocol 2 of 1977. Accordingly, Article 4 of the ISTR statute empowers the tribunal to prosecute violation of these two provisions. The main feature of the Article 4, which is the violation of the Article 3 common to the Geneva Convention and additional protocol. Here I'm going to read out the contents of the Article 4. The International Tribunal for the Rwanda shall have a power to prosecute the persons committing or ordering to be committed serious violations of the Article 3 common to the Geneva Convention of 12 August 1949 for the protection of the war victims and additional protocols to thereto 1977. These violations shall include but shall not be limited to violence to life, health, and physical or mental well being of the persons in a particular murder, as well as cruel treatment such as torture or any form of the corporal punishment, and collecting punishments, taking hostages, and acts of terrorism, outrages upon the personal dignity, in particular humiliating and degrading treatment, rape, enforced prostitution, and any form of the indecent assault, pillage, the passing of the sentences, and the carrying out the execution without previous judgment, and threats to the commit any of the foregoing acts. So these were the main feature of the uh, next tribunal, that was the International Court Criminal Tribunal of the Rwanda. So finally, students, the development of the establishment of the International Criminal Code and its statute. Article 8 of the International Criminal Code statute marks the most ambitious attempt to codify the concept of the war crimes. The drafters of the ICC statute generally sought to reflect customary international law rather than create new laws. Although Article 8 purports to be the reflective of the existing sources of the war crimes law, many provisions from previous instruments were excluded because of the lack of the consensus on their customary law status. For example, the provision of the use of the chemical or biological weapons. Article 8 also represents a progressive development over the earlier codification of the concept, particularly since it's covered the non-international armed conflicts, as well as defining the crimes in a considerably more detail than in the previous attempts. Article 8 of the ICC set out the approximately five offenses and defines war crimes by reference to two sets of primary rules, namely the Geneva Convention, paragraph 2A, clause A and C, excluding the additional protocol, and international humanitarian law, generally paragraph 2, clause B and C, including the additional protocol. The second division of the list in that relating to the type of the conflict to which they apply, international or non-international conflicts. So these are the 15 offenses which set out approximately in a statute, that is the Article 8 of the ICC statute. Accordingly, the definition of war under the Article 8 of the ICC includes four lists: a list of violation of the Geneva Convention 1949 during the international armed conflict, Article 8, uh, Article 8, Subarticle 2, Clause A, an additional list of the 26 prohibited acts under general international humanitarian law relating to the international armed conflicts, same which defined in same Article 8, subarticle 2, clause B, a list of serious violation of the common Article 3 of the Geneva Convention during a non-international armed conflict, Article 8, subarticle 2, clause C, and a list of an additional 12 prohibited acts under the general international humanitarian law relating to the non-international armed conflicts is Article 8, subarticle 2, clause C. So Article 8 we have already discussed, and there were also a project. Some of the students they have done project on the topic, that is the International Criminal Code, where particularly Article 8 gives us the jurisdiction of the ICC on the certain crimes which the war crimes is included in that, and Article 8 gives us a comprehensive list. There are 50 offenses which come in the ambit of the war crimes. So I am unable to uh, give all in a detail. So I will I here I recommend you in order to understand the offenses which come in the ambit of the war crimes, in order to invoke the jurisdiction of the ICC. So Article 8 has to be read and understand in a detail, in a very better way, and that will give you the understanding regarding the crimes which constitute offense. So thereafter, there are other courts which are created, such as the Sierra Leone is also generally regarded as the non-international Article 3 of the SCSL. Sierra Leone statute contains an identical provision to Article 4 of the ISTR statute. However, Article 4 of the Sierra Leone statute aids other serious violation of the international humanitarian law, which are intentionally directing attacks against the civilian population, intentionally directing attacks against the personnel, installation, material, units, or vehicles involved in humanitarian assistance, and conscripting or enlisting children under the age of 15 years into armed forces or groups, or using them to participate actively in hostilities. The definition, those students in this lecture, the definition of the war crimes which uh, fall under the jurisdiction of the special panel for the serious crimes in East Timor and the Iraqi High Tribunal conforms with the definition provided in the ICC statute. The ECCC, by contrast, have a jurisdiction to prosecute grave breaches of the 1949 Geneva Convention, which are defined in the same term as the Article 2 of the ISTY statute. This suggests that the conflict in Cambodia is regarded as the international, at least in part. In addition, the ECCC have a competence to bring to trial those suspected of the bearing the greatest responsibility for the destruction of cultural property during an armed conflict, pursuant to the 1944 Hague Convention for the protection of the cultural property in the event of the armed conflicts. So, what we have understand during these discussions, the international armed conflict, non-international armed conflict, and civil wars. So how these provisions, how to invoke the jurisdiction. So these development and the laws, which very much important, is that the convention which we have discussed in a detail, and the most importantly the very significant articles, protocols, which come under the discussion in our today's lecture. So I hope this lecture help you in order to understand so how these conventions and what convention which regulate the international crimes, international crime, which is the nature of the come in the under the international criminal law. So, which crime, the substantive part, the list of substantive part thoroughly, which we have discussed earlier, but in this series of lecture, we are discussing at length. So, thank you very much, students. And after the short break, this session is going. I'm going to end this session.